Recording. All right, we're in the courtroom. Mr. Wade is present as our counsel for the state and defense. Bear with me just a minute. Under my authority to change my mind when I think it's appropriate, I have been thinking over the evening about Ms. Miller's comments and Mr. Mizrahi's responses about the matter of the kidnapping allegation. And I've gone back and I have not looked at the final, I guess, instructions, but what I was given here yesterday, and probably updated copy that the allegation in the aggravating factors is that the first degree murder was committed while Mr. Wade was engaged in the commission of any kidnapping, and he has been found guilty of 2 counts of the kidnapping. And when we were doing the argument yesterday, I was thinking more in terms of the facts of the case and whether or not the jury was finding that there was a kidnapping. I had overlooked the allegation that he had been convicted of it. So here are all, any comments, Mr. Mizrahi? I mean, your suggestion was to reopen the case. This is an administrative matter, so I can't imagine that there'd be any reason to bring the jury back in and have you say, by the way, here's this.
Well, Your Honor, I do think Detective, Agent Meacham testified that they were convicted. I do think that there is evidence of that. Happy to reopen my case. We're going to introduce the printed judgment sentence from the court's website. And I can have Detective Meacham say, I'm a lead detective, and I was present, I have knowledge of all this. The defendant was convicted of 2 counts of first degree murder, 2 counts of kidnapping, and 2 counts of robbery. The judgment and sentence, I would just put in that part. I do not think it's appropriate for the jury to know the sentences.
That's right, because the judgment and sentence has the sentence.
The judgment and sentence. I can also introduce the verdicts from the previous jury with regard to their verdicts of murder, kidnapping. I mean, the reason why the state did not do this is he was found guilty as a matter of law in this particular case with this particular case number. And since talked about note, jury selection note, everyone's talked about it, I can talk about it, because that's sufficient evidence.
I had forgotten Detective Meacham had talked about it.
But we can do it. It will take a matter of 25 seconds for me to put Detective Meacham, who is dressed appropriately because he is a smart agent, and he could say that Mr. Wade was convicted of 2 counts of murder, 2 counts of kidnapping, 2 counts of robbery. Put in the first couple pages. This is the next number of the exhibit.
Thoughts or comments, Mr. Johnson? Or we don't do anything and it proceeds as is.
Well, our objection was to the court instructing the jury that Mr. Wade had been convicted of 2 counts of kidnapping.
Absent some proof that he...
Correct.
But I had forgotten, Detective Meacham did paraphrase at least that, and so much of this has been paraphrasing anyway, that well,
I'm happy to do it.
in the grand scheme of, I won't say that. Okay, am I right to change my mind? Never mind. Are you ready to proceed with the arguments, Mr. Mizrahi?
I'm ready to proceed with those. We're not moving to the other thing.
We're moving on. We have all of our jurors here.
Your Honor, I have just a couple brief things I wanted to address.
Okay, sure.
One, I'm moving the court for leave to be the person on behalf of Mr. Wade who does objections should the need arise for any state's closing. Mr. Johnson is closing on behalf of Mr. Wade, but obviously he's trying to mentally prepare. And so we're not asking to have all of us jump up and object, but I understand the court's ruling that given that he's
Not capable of giving an argument and making objections at the same time.
Of course he is. I think it's appropriate to have 2 lawyers, one who's focused on giving a closing argument to hopefully save his client's life, and the other who's objecting on behalf of the defendant. I Again, should the need arise.
All right, that would be an appropriate application.
And the other thing, I discussed this with Mr. Retrial, I know he doesn't agree, is it has been my practice, because of judicial suggestion, that the courts read the instructions before the arguments. It was suggested to me by Judge Malone. It's just worked pretty much seamlessly in all of the cases where it's happened.
No.
Okay.
If anybody's going to have the last word of this jury, it's going to be me.
Okay. And then lastly, I'm moving limiting to preclude similar type arguments the state made on behalf of the state of Florida in Mr. Wade's closing argument previously. There were two that were referenced as errors specifically in the Supreme Court opinion affirming. One was that a life sentence was the easy way out, and essentially...
Ms. Miller, I am not going to buy anybody in their arguments. If you have just received great permission to object when it's appropriate.
Okay.
So please do so, but I'm not going to try to tell you guys in advance what to say or what not to say.
Well, I just want to be clear, the Supreme Court has put on notice what errors were objectionable and error-free.
And you know what? That's all past. I really don't care what they said in that case. We have something new and fresh, and if you have an objection, let's do it.
I totally understand, sir. I'd like to put everyone on notice, so if they should happen when we move from this trial, the argument is it's not an error.
It's not going to be because anything that the Supreme Court says. It's going to be because I agree with you that it was an inappropriate argument at this point. This is all de novo. We're starting over again. Would you care to address the jury? Do we have the jury here?
Yes.
If they are...
We printed, Mrs. Morris was kind enough to print copies of the instructions for everyone as well.
Oh, okay. How about for me?
Okay. Sarah, you
Did somebody print a copy for me?
Yes, sir.
Okay.
Approach?
Certainly. Now, is the verdict form here too, or is it, that's just...
Alan, Mr. Rocky, when did you change this?
No, I mean, I'm sorry, the verdict forms were wrong. Just look at it and make sure it's right.
What was wrong with the website?
Reggie Sumners is not the same as Carol.
Oh, I see.
And the style of the font was wrong.
Well, while she's looking, go ahead and bring the jury out. We can, if there's any objections, we can do that later. All right, our jury is returned. Be seated, ladies and gentlemen. Members of the jury, good morning. We have now concluded, as you know, both the state and the defense's case in chief. phase of these proceedings, in which the attorneys will have an opportunity to give you their closing arguments. I started this off by telling you, and I remind you now, that what the attorneys say is not evidence. The only evidence is what you have heard from the testimony of the witnesses and or will have seen or will see from the tangible exhibits that have been introduced. However, I ask that you pay careful attention to the arguments of counsel because it is their opportunity to suggest to you how each side believes that you should interpret and weigh the evidence which you have heard. The final decision about that is yours, of course, and yours alone. So I do ask that you pay careful attention to what they have to tell you. For reasons of custom, really more than anything else, Mr. Mizrahi will have the opportunity to speak to you first on behalf of the state. Mr. Johnson then will speak to you on behalf of the defense, and then we will have the instructions from myself. Mr. Mizrahi.
May it please the court.
Yes, sir.
Counsel. Ladies and gentlemen. Lady Justice is blindfolded because the scales of justice are moved by unbiased, objective truth. Each one of you has taken a solemn and sworn oath where you have asked God to help you be your own Lady Justice, to analyze what is just. What is justice for the two premeditated murders that this defendant has been convicted of? The question you have to answer is what is justice? What is the proper sentence for these evil crimes? The question is not, what purpose does the death penalty serve? Am I getting vengeance or anger on behalf of the victims? Is it about his production in prison and how many books he's read? Or whether or not he's able to write letters to his niece? That is not the question you have to answer. The question you have to answer is what is justice? What balances the scales of the universe? What is a fair punishment? Each and every one of you swore that you would use the law as your guide in this very unique and solemn process. Because the law doesn't leave you in the dark about what justice is. The law provides the balance to those scales. You don't have to speculate or wonder, is death an appropriate sentence for these facts? Because the law tells you, screams to you, overwhelmingly informs you that those scales will be in balance if a death verdict is reached. If you use the law as your guide, your decision, as grave and as solemn as it is not terribly difficult. The aggravation in this case so outweighs the mitigation that I submit to you, the only reason for a verdict of life is to interject your own opinion, which you are legally allowed to do, and ignore what the law says about aggravation and mitigation, and whether or not the aggravation outweighs the mitigation.
Overrule.
The aggravation outweighs the mitigation. The law says that death is a proper sentence.
Objecting to misstatement of the law.
Overruled.
As I have said, the law doesn't require it. But the law says that it is proper, legal, and just to vote for death in this case. Each of you swore and asked God for help when you promised that in the right case, with the right aggravation, that you could check that box. We're going to take some time and look and analyze what has been presented. The objective, undisputed facts of 2 evil murders, 2 evil kidnappings, and 2 evil robberies. The evil crimes planned and prepared, contemplated and debated and deliberated over time. Not spur-of-the-moment decisions, not heat-of-passion decisions, not hot cognition decisions, but decisions that required minutes to hours of hard labor in July in the South, digging holes days before, all the while knowing what they are for. Objective, over time, cold, calculated. Each morning when this defendant woke up, and according to his paid experts, waked and baked because he was sober when he woke up, the thoughts of killing Carol and Reggie Sumner were there in clarity. The thought of killing 2 disabled, weak human beings was being cultivated in his mind. His decision to kill over days and weeks is based on greed and not wanting to get in trouble. While the defense prepares made-for-TV, scripted, paid-for experts that say that he's scared of the dark, he in the dark is putting shovel after shovel on top of disabled human beings, with the only light being held by Tiffany Cole some of the time. That is the objective truth, the unbiased truth about this case. Using the cover of darkness, he buried 2 disabled people in darkness forever. Do not judge him by the tears of his family or by the lectures of his paid advocates, but by their behavior when he was free. Do not judge him by the photographs that they put in, but by the photographs of what he did. The evidence that Lady Justice considers and weighs in the balance is not supposed to be biased. It's supposed to be objective. It's supposed to be truth. The mitigation is a biased, paid-for cottage industry where professors and advocates come in here and talk about the $400 an hour or $250 an hour and how they have advocated for their positions and searched only for what they were paid for. They actually sat there and said, not only the experts, but his family as well, that not one human being that we have heard Monday, Tuesday, and Wednesday on behalf of this defendant asked one solitary question about the facts of Carol and Reggie's murder. And because of that, I submit you should disregard all of it. Because it is not objective. It is biased and paid for, and it should not affect the scales of justice. When they plaster pictures of Alan Wade as a child, that's not blind justice, it's sympathy. It's an attempt to sway you away from the crime to a sentence that is not based in justice, but a sentence based in emotion and sympathy, which of course the law gives you the right to do, but is that justice? Remember why you're here. It's not because Alan Wade was not a human being or a child or doesn't have people that care about him. You are here because that is who Alan Wade was. That is what he became of that young boy. A selfish person capable of these evil acts, who was only interested in money and limousines. Judge Alan Wade by what he did, by what he was capable of, the terrifying ordeal that he signed his name to, that his signature is under like a piece of artwork. Time has not dulled anything to do with the evil of these acts. It hasn't. Now, I understand it's difficult to go back that far. Shovels still have the dirt. Time does not heal all wounds. And I have said multiple times, and I think you've heard multiple times, the word grave. Pre-dug grave. Carol and Reggie Sumner are now in a grave. But in July 2005, they weren't put in a grave. They were put in a death chamber. A hole, a pit in southern Georgia, which was this defendant's murder weapon. So let's objectively look at what the state has to prove and what the aggravating factors that we've submitted have clearly been proven beyond the exclusion of every reasonable doubt. The first and frankly most powerful aggravator in this case is the fact that Alan Wade was previously, being previous to today, convicted of another capital felony. The crime of first-degree murder is a capital felony. Alan Wade has been found guilty of 2 counts of first-degree murder, and those convictions occurred previous to this proceeding. You don't get a free murder. 2 human beings, even if it's at the same time, don't get to count as one. If Carol Sumner was dragged, kidnapped, home invaded, thrown in a truck, and thrown in a death pit, this would be a death penalty case. It would be. But it wasn't just her. It wasn't just him. And these 2 lovers who finally found each other were aware that the exact same thing that was happening to them was happening to the person that they loved most in the world. And with their sharp minds and feeble bodies, they clung to each other in the trunk of that Lincoln. This aggravator alone outweighs any mitigation in this case. You don't get a free murder. Some murders are more aggravated. Some evil acts justify the ultimate sentence. And you should vote yes, as a matter of law and fact, that this defendant was convicted of 2 murders. The second aggravating factor is the fact that this defendant was convicted as a matter of law and fact in this very case, with this case number, of 2 counts of kidnapping. And that has been proven beyond a reasonable doubt. And just so you know about what the facts of kidnapping are, that's the duct taping and throwing 2 human beings in the trunk of a car for the purpose of killing them in a different state. If Alan Wade and Bruce Nixon had home invaded the Sumners' house, tied them with duct tape, thrown them in the trunk of their car to drive in July some 33 miles through the woods, all the way to the woods of Georgia, where the car is bumping up and down in the woods of Georgia to a pre-dug pit, to get ATM information out of them and let them go, this case would be worthy of life without the possibility of parole. But they did so much more. And that is why this is a weighty aggravator. I want to be clear that the robbery convictions, although they are enumerated felonies, should not be considered in this aggravator. They should be considered in the next, one of the next aggravators having to do with pecuniary or financial gain. But this is for the kidnapping, for the sheer terror of a kidnapping that these 2 human beings had to endure at his hands. His hands. And again, that checkbox should come very easily, since it has been proven and he has been found guilty of it. The third is the motivation behind it, which he was committed for the purpose of avoiding and preventing a lawful arrest. The only way you can take somebody's money out of an ATM machine, $100, $500 at a time, is if they're not around to report the crime. Why else are they taking the steps to kidnap, to pre-dig a grave and kidnap them and put them in the middle of nowhere where they would find them, but for the motive being that they didn't want them to report the crime? But more importantly, they didn't want the bodies discovered. Do you know how much easier it would have been to walk into the house and just kill them while they're there? If you do that, that crime will be discovered and they're going to be on the trail of your ATM usage. The only way to assume the identities of Carol and Reggie Sumner is if these 2, albeit weak, feeble, and infirm people, but independent people, are just disappear. And then you can hit the bank all you want. You could pretend that you're Carol and Reggie Sumner. They didn't count on Rhonda Alford's love. They didn't count on that. When the police went there, they had, well, there's nothing there. No signs of forced entry. Car's gone. These people are adults. We'll have no crime here. And then this defendant, along with his co-defendants, while they're all together, going from hotel to hotel to hotel in South Carolina, Michael Jackson and Tiffany Cole calling and pretending to be the son. That aggravating circumstance has been proved to you beyond the exclusion of every doubt, and you should consider it because the motivation behind this crime is so egregious. The fourth is the other motive. The first-degree murder was committed for financial or pecuniary gain. This wasn't a situation where a domestic violence situation got out of hand. heat of passion, or some person that had previously harmed you, did something to you, and you went back and got revenge. Nah. This was done for money, and the reason why they had to kill the people was to get away. Two primary motives that were hand in hand. They wanted money, and they had to get rid of the people in order to do it. Again, a very important aggravator as listed, enumerated by our laws, that if found, makes the defendant eligible for the death penalty. I submit to you, if this was just financial gain, that was the only aggravator out there, you may have a weightier decision before your hands. That may not be the worst of the worst. It's just one of 7. You should absolutely weigh on the side of aggravation, and you should consider it when voting for death. Now we're going to talk about the 3, in addition to the kidnapping and the prior first-degree murder. These 3 aggravators, the state submits to you, are incredibly weighty aggravators. And they, each one of them independently, the state submits to you, outweighs all of them. And that's true with the first 2 as well, kidnapping and first-degree murder. So the next one is what is referred to as heinous, atrocious, and cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means that the act was designed to inflict a high degree of pain with an utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to both Carol and Reggie Sumner. I submit to you that if Carol and Reggie Sumner had 2 bullets put in the back of their head while they were in that grave, that would have been unnecessarily torturous, because they know about their impending death for a long period of time. They had no illusions in the back of that trunk that something really, really bad was going to happen. That's why they were hugging each other, spending those last minutes and seconds of their lives clinging to their love. And that torture, that terrifying ordeal, is contemplated by our law objectively as a reason to return a verdict of death. It shows what he's doing. Right? It shows not what he's capable of, but what he is. This wasn't a potential, this was an action. Heinous, atrocious, and cruel. And let's be clear that this defendant, along with Michael Jackson, were the 2 human beings that were covering Carol and Reggie Sumner in the dirt. Pursuant to the testimony of Bruce Nixon, and pursuant to your common sense. Because if you analyze the totality of this case, even if you don't think about Bruce as much of a witness, somebody had to bury these people alive. And it makes no sense that the 3 of them dug the hole 2 days before, knowing they were going to kill them, and then only one buried them afterwards. I've heard over and over again, there's 2 good shovels. This one, the ones that were used. Even the snow shovel could have been used to cover people. It may not be a good big shovel. 4 shovels, 4 people, 2 horrible crimes, 2 horrible murders. And this, in and of itself, is enough to vote for death. 6th aggravating factor is what we refer to as cold, calculated, or premeditated. Heightened premeditation. First-degree murder is having a conscious intent to kill and having the ability to reflect upon that decision. I'm going to pick up the PowerPoint clip. That's a premeditated intent to pick up. It can be formed in an instant. And the people that are convicted of first-degree murder, that's what the state has to prove. In an instant, you made the decision to kill and had some opportunity to reflect. That's why this first-degree murder is different from the countless other first-degree murders that unfortunately fill this courthouse. This first-degree murder was not an instant reflection. It was cold. Calm and cool reflection, cold cognition. Calculated means have a careful plan, a prearranged design to commit the murder. A killing is premeditated after deciding to kill. A decision must be present at the time of killing. There is no time period. The time period must be long enough to allow some form of reflection. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. And there is no moral or legal justification for it. That means if you find out that someone has, let's say, raped your child, that may not have any legal justification if you plan on killing the person, but it does have some moral justification. Neither applies here. There's no legal justification and there's no moral justification. This is the personification of cold calculated premeditated. If you look up cold calculated premeditated in the dictionary, they got a picture of these four people saying their crime is cold calculated premeditated because it didn't take minutes, it didn't take seconds, it didn't take hours, it didn't take days, it was weeks. That, mind you, all of these things apply to two people, not just one. Finally, Carol and James Reginald Sumner were particularly vulnerable due to advanced age or disability. You heard the perpetuated testimony of Rhonda Alford, Carol's daughter. You saw the proof in their house. You heard from the medical examiner who talked about how atrophied, how weak, how brittle their bones were, how the advanced diabetes, the leg brace, the cane, the liver cancer, all of these things made these human beings an easy target. The law provides for extra protection for those that are especially vulnerable, whether they be children or disabled adults. And it also contemplates that they knew how easy this would be and how cruel. Time has not dulled the horror, the terrifying cruelty of July of 2005. Michael Jackson is waiting for his turn. Tiffany Cole is waiting for her turn. And Bruce Nixon, the last person to be involved in this, the person recruited by him, his best friend, is serving out the better part of his life in prison. But frankly, none of those considerations are relevant. It's this defendant that's on trial. And you are to decide what is just for him. It is an undeniable human trait or desire to try to understand the unexplainable. Why on earth do we make movies and TV shows about serial killers? Why are we fascinated with the unexplained evil acts that human beings perform? Why do we latch on to explanations, psychological analysis. It's a human trait or characteristic to want to not look evil on the face and have no explanation. And we understand that you want an explanation. You want something to hang your hat on. Oh, Alan Wade committed a home invasion robbery and duct taped Carol and Reggie Sumner and put them in the trunk of their car and got gas and drove to southern Georgia where a pre-dug death pit awaited these two human beings and buried them alive, and then spent the next several days hopping from hotel to hotel, drinking and doing drugs, and hanging out with his buddies. He did that because his mom didn't love him. You need, as lady justices individually, to critically analyze what the friends and family of Alan Wade and over $50,000 of U.S. currency gets you. Analyzing this litigation. I'm going to go through every witness the defense called, and explain to you why the state submits it's either not mitigation, or if mitigation, it should be given very little weight, and whatever weight you give, it doesn't even come close to the aggravation in this case. They called Dr. Steinberg the first witness, one of the premier experts in juvenile brain. By the way, I could spend one word on talking to him, or the family, which reviewed some transcripts. But he basically just came in and gave his canned presentation on what the adolescent brain is. He used the words adolescent, tries to put Alan Wade in the same category as the king. I like to use the word young adult, something that as a society we have agreed upon when we're 18 year adult. Interestingly, this is what he said. That adolescents, and this is all common sense, he can tell you anything that any one of y'all don't know intuitively. That 18-year-olds struggle with impulse, but their other thought processes, they do just like adults. He actually corrected me and said they're identical. When you have days to think about a crime, there's no difference between an 18-year-old and a 35. He said, one of the foremost experts that under cold cognition, 18-year-olds have no good. All the science we know that intuitively. Yeah, they may make rash decisions, man, they may do something impulsively that doesn't make a lot of sense. But when they sit down and digest things and go to bed, what do we all say? Sleep on it. When they sleep on it, there's not a lot. In fact, he said, this mitigating witness proved the fact that this defendant is 18 years old with these set of facts is not mitigating at all. It's just a number. It's a number that they want you to hold your hat on, and they're entitled to do it, and you can do it. Not commercial. But when you look at it medically, scientifically, when you spend days and weeks planning, it's not mitigating, and that's what one of the foremost experts on the planet said. It's not. They call it Pastor Schwartz. Pastor Schwartz provided incredible love, structure, and mentorship on a 2 to 3 to 4 times a week, a minimum of 2 days a week basis. Now, to be very clear, Pastor Schwartz and that church in McClady is not the church where the defendant just recently claimed he was abused. Not a completely different church. And he went there at least 2 times a week. Who got him there? His mother. Providing, as best she could, the kind of structure that we all need. A loving, God will play. The mission of this church and this youth group was to reach, to connect. That's what they do every day. You saw how caring he is. He came from Europe. What kind of human being Pastor Schwartz is? Never saw angry, never saw rage, never saw drugs or risky behavior. Was upset about the ping pong table, sure, but they ended up giving it himself. Mom got him there all the time. And, takes the community. Well, Pastor Schwartz was part of that community and did his best. State submits it's not litigation. If anything, it's aggravation. You can't consider it as aggravation. That's not legal. It's certainly not litigation. Alan Wade Sr. was called to testify to essentially what has become a problem in our world. When fathers either never get married or get divorced, they sometimes become absent. And anyone in this courtroom doesn't have either themselves or a close friend or family member that has gone through this. It is unfortunately part of our world. There are millions and millions of boys and girls that grow up without one parent. And even he said, I tried to do right. Maybe not as good as he could have. Maybe he was poor and lost his job and had the house foreclosed. But he loved his son. And that is a fact of Alan Wade's life. It is a fact of millions of others. And I submit to you, it is a fact of his life, but it does not in any way significantly mitigate the aggravation of this case. They called the defendants Nikki Craig, who I guess is his sister-in-law, who was married to his brother. And basically what she testified to was Alan was a really, really good boy. He's capable. This was because they present that he's a broken person. That really his foundation was so terrible that this was almost an inevitable conclusion for that terrible. The evidence doesn't support that. The evidence, of course, he spent summers on the Cape. They're from Massachusetts, right? I know that's an exaggeration. These weren't rich people. But he spent summers with loved ones and family, doing things the kids are supposed to do in the summer, and he was a good kid. We don't dispute that, because it shows that he was capable of doing what was right and chose wrong. Chose to do evil acts. It's not mitigation at all. The Dobson story. That's the middle school principle. When they teach us in persuasive argument class, the defense did a fantastic job of presenting that. And we're not going to say don't consider that, because you can say somebody doesn't love you, but you can tell a story like that, it gets home. It's a great persuasive argument. And it is shocking to hear that. A couple of points about that. They asked Free about it, didn't they? And that's Ms. Wade about it. I don't dispute Mr. Dobson. I don't think he's lying when he comes in here. But there's no context. Frida Wade provided the context of what she had to do with Alan Wade every day, every hour, every minute, every week. That she was trying to do right by him and Frida. It does touch a heartstring to hear that story. What it also shows is that there were people out there that he knew existed, that cared about him. They said, no, wait, we can get you on the right path. Let's try to fix this. Let me tell you, if you can't trust a parent, go to a teacher, go to a dean, go to a principal, go to a coach. The human beings are out there to help you. Go to a church member. And this happened. And also what Principal Dobson said is that she was an involved parent. That every time he picked up the phone, she was responsive to doing what was right by Alan. He caught her in a moment where she was tired of hearing about him, and that's enough. He also said that he never, ever, ever got DCF, Department of Children and Family Services, involved, which school administrators can't do and do all the time when they see that the mother is strung out on heroin or that the kid is truly being neglected. None of that ever happened in this case. There are the worst of the worst families, and Alan Wade did not grow up in the worst of the worst. Also, Principal Dawson said there's no drugs or alcohol in the kingdom. Then they called, I guess on, where was it? It was Tuesday, Dr. Castillo. Dr. Castillo, with the $250 an hour, over 91, who knows what they're up to now, hours, was an advocate for the defense only in this case, and nothing more. She prepared 108 slide PowerPoint the night before. Never did the report, but did a PowerPoint where she threw on baby pictures of the defendant and then tried to claim later, oh, those were to show the chronological pages, which she never mentioned. But I never talked to him about the case. Judge her credibility based on the fact that she's educated, I get it, she went to colleges and got a lot of degrees, smart person. But she said, as part of her trauma consideration, that a 17-year-old who steals, who does criminality, who does drugs, and a 17-year-old boy sitting in limousines, drinking champagne and throwing $100 bills around, that person is traumatized by having sex with 20-year-old strippers or 25-year-old strippers or 50-year-old strippers. Doesn't matter how old they are. And somehow he just didn't want it. So that was traumatic for him. They included that as part of their sexual abuse. These people were meeting with him, and they testified to it. It was under oath. They asked for help from God under oath to tell the truth, and they said that we met with him specifically to uncover trauma. Trauma that no one has ever known about until this week or a couple of weeks ago. I have no idea if the sexual abuse happened or not. I do know that nobody knew about it until right before this trial. And there was no investigation on the back end. She says things like, I believe that Michael Jackson was an influence because the person I'm paid to interview told me so. Oh, did you go back and watch Michael Jackson's interviews? Did you go see all the things? How about Bruce Nixon's interviews? Did you go back and see what Tiffany Cole said about what everyone did? Did you even go back and see what Alan Wade said? Did you even ask Alan Wade? If you say he's an influence, how was he an influence? How was Michael Jackson influencing you to shovel dirt on Carol and Reggie Sumner? That's a question. Not asked. Every human being has gone through trauma, each and every one of us to varying degrees. We talk about childhood trauma. We've just gone through a global pandemic where children are wearing masks and missing school. Everybody is fearful. Life is hard. Trauma is hard. But human beings are resilient. And we don't quibble with the fact that people that commit crimes may have more trauma in their life. Many of us are blessed. But many people that aren't don't become criminals. So this is the disconnect. Walking down the streets in virtually every city in our country, you're going to see the homeless. You're going to see drug-addicted people. You're going to see people that we all feel sympathy for. And those people, they even said this, by the way, that generally speaking, the trauma affects health, intellectual ability, none of which affected him, by the way. Intellectual ability is high. Drug use, it really doesn't have anything to do with violence. This is the disconnect. Your mom doesn't love you or you get hooked to drugs, it doesn't mean you bury two people alive. There is no cause and effect here. And they said that. All people have gone through trauma. People who commit crimes may have gone through more trauma, but does that mitigate or lessen every criminal's punishment, the fact that they had a tough life? I submit no. They call Jerry Gainey, another good adult role model, mom's boyfriend and husband. He didn't want to be a father, which we respect. He didn't try to be, so he wasn't doing bad things. But he was there working every day, showing Alan Wade, at least by example, how to live your life. They called Eli Griffiths, the gentleman who said that he was neutral to this defendant. After knowing what he did, he was neutral. And he told you that Bruce Nixon was guilty of murder, which he pled guilty to. Not really sure how that's mitigating at all. They called Dr. Danziger, which is the drug person, and she claimed that she did an investigation because she talked to Bruce Nixon too. And they said that they did drugs. And the state's not submitting that these people weren't doing drugs. One of the reasons to rob someone when you don't have a job, when you can't afford drugs, you rob them to get drugs. There's no dispute about that they're using drugs, but that's the motivation behind the crime. Is that because you snort some cocaine, you're capable of burying people alive? Because you drink a few beers, or 6 beers, or 12 beers, you're capable of burying people alive? Again, the disconnect between drug use and violence, there is no connection. But it shows you the credibility of these people. He's paid, I think she was $200 an hour. But she didn't do anything to see how Alan Wade was behaving at the time. She took his word for it. This is how I was behaving at the time. Because the next witness is Miss Rodick, who said, I sniffed that boy all the time, and I sniffed all of the kids, and he wasn't doing drugs or alcohol as far as I knew. Does that mean he wasn't? No, he's probably good at sneaking it. I have no doubt. But this concept that all he's doing from the time he's 12 to the time he's arrested is doing drugs is not supported by the evidence, no matter how much you pay an expert to say it. Because the truth is the exact opposite. Almost every teenager, I won't say all, almost every teenager at some point experiences, at least with alcohol. And the statistics are going up and up and up as drugs become more and more accepted and available in our society. Drug use by teenagers is, again, something that's a fact of our lives that does not equal the capacity and the ability and the fact that this defendant did murder, and it does not mitigate. And again, Miss Roden was another adult that this defendant knew loved him, intervened on his behalf, and that he could call any time. Get a nice meal if you wanted it. They called Ron McAndrew, who said despite this defendant's being in confinement that did not put him with other prisoners, he still was able to violate the rules. That's not a reason or an aggravation. It's not a reason to kill, but it's not mitigation. He did switch or had an armband issue while he was in the Duval County Jail, which is the means by which people escape, but that's not a reason. That's not aggravation. Mr. McAndrew said, I only take certain cases. Trying to give you the impression that it's not the money that motivates me, it's the character of the people that I interview. He said, very strong. I said, so you're retained on Michael Jackson's case too, right? He said, which one? I got a couple. And I go, no, this Michael Jackson. Let me show you your report. Oh yeah, this is Michael Jackson. The one that they're going to point out. And I agree. Michael Jackson's a bad man. He's got his case too. All right. Don't take every case. Okay. Well, you can see you can judge his credibility based on those statements. Then we heard from Dr. Janes. Her testimony, which was, I submit to you, she said, I think she said, I agree with Dr. Steinberg, I agree with him, he's a foremost expert, I trust him, I was here for his testimony, I agree with it. But her quote, you rely upon your own memories, of course, but all criminal behavior is hot cognition. That because it's criminal behavior, we're going to put it into the thing that it's a spur of the moment, that you're intense and incentivized over days and days and weeks. It can't be hot cognition. It has to be cold cognition. You can't run a race car in the red that long. Confirmation bias is all you saw from Dr. Janes. She says, I get the feeling that he was afraid of Michael Jackson, that he made me. She equated a brief, we don't know exactly how long, but months, maybe a year or so, relationship of Alan Wade and Michael Jackson to a domestic violence situation where generally a woman, sometimes it's a man, but generally a woman can't leave because she has children with the person, or the person is the financial supporter of the family, and they have a home together, and sometimes those considerations get in the way. You're talking about a buddy they go out drinking with and hooking up with strippers. I get the feeling that he was afraid of Michael Jackson. She hadn't even seen the picture of them throwing $100 bills and sipping champagne in Myrtle Beach. There's no investigation. There's no objective facts surrounding that. She was asked the question, it was by one of you. Is it possible, was the question, is it possible that when you do something over days, a crime, and you contemplate it over days, that is cold cognition as opposed to hot? And the whole difference between cold and hot is that juveniles have a hard time regulating their behavior in hot cognition. So that was the whole underlying issue. So the question, the reasonable question, is it possible that a crime that lasts for days and weeks of contemplation and pre-digging death holes and all this stuff, that could be cold cognition? I submit to you, she wouldn't answer the question. She just went on another lecture about what she thinks about adolescent brain development. She wouldn't answer that question. She wouldn't answer the question because common sense tells you it's obviously cold cognition. She also said something, I think it was another juror question, about whether there's any difference in the brains of females and males, and her answer was no. And that shows you that the underlying science surrounding all of this is not ready for prime time. Because, as Dr. Steinberg indicated, females offend at a far less lower rate than males. The development of the brain has very little to do with any of this. That's where that female brain comes in. Again, the paid-for bias should not influence your verdict. Patricia Page was called, and again, showed you the exact opposite, showed you the truth about Alan Wade, not the paid-for truth. Fascinating testimony about the staying out late and playing basketball. That she had a curfew, and again, another loving, God bless her, she took care of Alan, his sister, half-sister. She did right by him, he's a good kid, but when I told him about a curfew, and he would be playing basketball, hot cognition, with his friends, peer pressure, she was like, Alan, told you about your curfew. He would scream out to the kid, I told you I was going to get in trouble, dang it, and he accepted and responded. All the paid-for experts say they don't appreciate what they're doing. Yet, Patricia Page says, well, yeah, he knew the consequences of his actions, and he accepted them. And she gave him love and a place to stay. You heard from Jade Craig, the niece. That is hard. It's hard for me to sit there and listen to it. I have no doubt that she feels a connection to this defendant. but it shows that he's capable. It shows that this is part of him that he chose to ignore. It shows that Frida Gainey did not create a monster. He chose to be one with those acts. It's sad that Miss Craig's best male role model was not this defendant's brother, her father, but the two-time murderer who was a pen pal to her in jail. By the way, she's a pharmacy tech. His family are victims. Maybe not just like the Sumners, but they are victims. This defendant betrayed them, and their tears are not mitigation of this defendant's behavior. They are sympathy. In every single murder, there is the possibility of a mom, sister, a brother, an uncle, a daughter, coming in and crying on behalf of the accused or the convicted. That is his responsibility. He wasn't thinking about them when he was hitting ATM after ATM after killing two human beings. The most truthful window of all of it was the second to last piece of evidence you saw. And I submit to you that the state of Florida has very little to quibble with Ms. Gainey's testimony, that gave you the greatest insight into this defendant's life. She sat there in those rows and was accused of being, if you would just listen to the beginning, the worst mother on the planet. She wasn't. You should judge her credibility versus the paid experts that sit in judgment of her. Never walking a day in her shoes. Frida Gainey is a victim of this defendant. And I submit to you, other than the Sumners and their family, no one has suffered more than Frida Gainey because of the voluntary acts of this defendant. I'm going to let her testimony speak for itself about whether or not their hard lives together somehow mitigate what he did. Talk about the allocution. The allocution of Alan Wade. A window into his remorse. Even yesterday, he refused to take accountability. He refused to take an oath and ask God for help. He refused to be cross-examined. These were his choices. The law gives the protection of the Fifth Amendment to each and every one of us, and this defendant chose to not use that right and chose to hope to pull on a heartstring of you by somehow having the hubris to believe that him saying sorry means something. I am tormented by my cruel, careless acts. What acts? I am sorry for treating you both without a shred of dignity and hurting you. How'd you do that? The hubris to believe that Carol and Reggie Sumner could have some cosmic consciousness where they would feel his regret? I don't think any of us know about any of these things, but I submit to you that Carol and Reggie Sumner have no interest in having a cosmic connection to the person that was putting dirt on top of them and decided to write an allocution to you 17 years later in a hope that somehow that will affect your verdict. I apologize for not cooperating? I'm sorry for inconveniencing you? And then he goes on to basically talk about himself the whole time, and all the books he's read, how much he's learned. All the while, Carol and Reggie Sumner can't read another book or learn another piece of information. And he hopes that that's somehow justice. It's not. And it's a window into him. How even 17 years later, he's trying to manipulate. It's why we played the jail call. Why we called back Detective Meacham. You had to hear that. And one more thing about Frida, I'll mention this because it was crystallized in that jail call. She says, you don't listen to me, Alan. I've been telling you to get a job and fly straight, but that's not your style. And she starts yelling at him. Like a mother probably should do after her son's been arrested for murder. She starts yelling at him. He manipulates her by saying, you even think I did this? Which he did. He did do it. And then she said, I'm sorry, sweetie. Did you get my letter? I anticipate you may hear, I guess, argument in this letter about Bruce Nixon saying the state manipulated him, which is really just a plea. Why they talk about the letter, but the last P.S. to basically his surrogate mother is, P.S. send me some money. And I remind you that the defendant is convicted, and it's not a consideration for you about whether or not he is responsible for what he did. I just want to mention about that later. This is a desperate attempt by an incarcerated person to get money out of one of the few people in the world that cares about him. And so he's saying things that he thinks she wants to hear. Because he had to sit on that witness stand and say, he's responsible. He got me into this thing. He's my best friend. And we did this together. There are millions of Alan Wades with his upbringing and background. Drug addicts on the street don't go around burying people alive. I want to talk about Michael Jackson because Michael Jackson as you can see right there, Michael Jackson is a bad man. Yet they are trying to say that Michael Jackson was some sinister, I don't know, gang lord over Alan Wade. I don't know. He's bad. We're not saying he's not the mastermind. We're not saying it's not his idea. We are not saying he was the man with the plan. We are not saying that Michael Jackson did not have a terrible influence over Alan Wade. He did. Alan Wade had a terrible influence over Michael Jackson. These guys were friends, despite a couple of 5 years difference. And you know why you know that? Is the second reason we played that jail call. Ooh, I'm going to kill Michael. Well, I'm not going to kill him. I'm just going to beat his ass. Because he said we weren't going to get caught. He promised me we wouldn't get caught for this. And now we got caught. And I'm going to beat his ass. That's the truth about the influence of Michael Jackson. I'm going to beat his ass. It was his idea, but to characterize this as substantial domination is not supported by the objective evidence. The objective evidence of Alan Wade, days after he's arrested, saying he's going to beat his ass and kill him. Well, not kill him, because we got caught and Michael said we wouldn't. You know, they act like Michael Jackson had him kidnapped. Is there anything objective in the evidence that tells you Alan Wade does anything that he doesn't want to do? Mom has to camp out outside the GED to make sure he doesn't leave. By the way, high intelligence. By the way, not going for school, failing 6th and 7th grade, all these things. He goes in and does his high school equivalency, having not opened a book, and all he is high on goofballs and cocaine and doing every drug in the sun. He goes in and passes just months before the crime, by the way. In January of 2005, he goes in there and gets over 50 percentile in every single category in his GED. That's the objective proof. Does the teen challenge that she tries to get him involved in, where they're going to kidnap him and scare him straight, were they able to kidnap him and make him do things? Was his mom able to kidnap him and make him do things? No. And Michael Jackson didn't kidnap him and make him do things. Alan Wade did exactly what he wanted to. He was drawn to Michael Jackson because of what Michael Jackson could provide, what he wanted. He didn't want to go to school and go to church and do right and clean up and get a job. He wanted to do drugs and hang out in limousines, and Michael was good at doing that. That's all it is. This is not a numbers game. You're going to hear a lot of mitigation that they submit is mitigation. It will not, by weight, overcome the aggravation. And then really we get down to really the bottom line of what their argument is and what your decision is. You, as lady justices individually, are not unmerciful. You are not cold-hearted. If you hold a young adult accountable in this case, if you differentiate this murder from the hundreds of drug robberies, domestic killers, and all the other premeditated...
State is vouching.
I didn't hear them.
Improper argument, the state is vouching for this being a death penalty case. This law substantiates that's improper.
Overrule.
You decide whether this is a death penalty case. I don't have the pin on that. You guys do. But you are not unmerciful if you hold a young adult accountable and you differentiate these evil acts from other first-degree murders. You can have mercy for this defendant's family, mercy for the Sumners and their family, and even mercy for this man, and still hold him accountable, fully accountable. It is not unmerciful to find justice and follow the law. It is an act of mercy. The mercy is the due process. The mercy is the deliberations, you individually and collectively sitting around and giving this the weight it deserves. That's merciful. Unlike these defendants' acts. You are following the law mercifully, unbiasedly, to find justice and balance justice in this universe. Carol and Reggie Sumner, after years of loneliness, found each other and swore to each other that they would be together until death. Never could they have imagined how heinous, atrocious, and cruel those deaths would be. The terrifying ordeal at the hands of this defendant. Each and every one of you took an oath, and you swore, asking God for help, that in the right case, that you would be able to individually check the box that says death. Time in no way, shape, or form has dulled these evil acts. Your verdict will penetrate through time to forever define the punishment that is just for what he did. Which cases are the worst of the worst? Only the worst deserve the ultimate punishment. Time has done nothing to dull the sting of these vile acts. Nothing has brightened the soulless darkness where these crimes were conceived in this defendant's mind. There are cases, there are evil acts that justice is served by voting for death. And individually and collectively, the state is asking you to show both justice and mercy by carefully considering the evidence and holding him fully accountable for his crimes. Thank you.
All right, thank you, Mr. Mizrahi. I think a short break would be appropriate. Members of the jury, if you'll step back in the jury room, we'll take about a 10-minute recess. All right, the jury has left the courtroom. We'll take about 10 minutes recess. Stranger, I thought I saw you. I see you. Yeah, you know, I mean.
Got no problem with that.
Ready to bring them out to do it out here.
I don't think so.
I'm not going to be instructions on the screens. I'm not going to be instructions on the screens. It's not going to be.
Do you want me to take these down?
email it to you.
Well, I'm not. Maybe somebody complained. going to tell you whatever the outcome is, you have put your heart and soul into this. I'm intentional. So you did excellent work. As I said, I don't want to be a criminal and go for you.
So remember this, this is Jennifer, people, that's what
That way I know how many codes. That's what Will wants
What's that they do? They try to circle the chips.
Verified.
Kid that works in the office is the innkeeper. I don't know which one. The original jurors, he's dead now.
Let's come to order, please. The time is 10 minutes to 11. Mr. Wade is present as our counsel. Just for record purposes, the reason for the delay is it occurred to me that we probably should address the the logistics of providing lunch for the jury, because I plan to ask them for a working lunch. My court reporter last night called me to tell me to remember to do that, and of course I completely forgot to do it until just now. So apparently the jury has now prepared their orders. Mr. Johnson, are you prepared to address the jury? Yes. If the jury is ready, have them join us, please. All right, the jury is returned. Be seated, ladies and gentlemen. Mr. Johnson, would you care to address the jury? Please do.
May it please the court.
Certainly.
Ladies and gentlemen, no matter what your decision is after your deliberations, Alan Wade will die in prison and will leave in a coffin. Alan Wade, 47 days past his 18th birthday, has almost been in prison now for as long as he was alive when this crime occurred. And no matter what happens, no matter what you decide, he will spend the rest of his days in the concrete box of prison until he dies. I know this has been difficult. This is a difficult case to be on. It's a difficult case to be a lawyer on, and I know it's been a difficult case to be a juror on. My job is almost done. When I sit down, my job will be done and yours will begin. And it's a difficult job. And I would submit that it's almost a job that no one should be asked to do. To decide whether a human being, this human being, lives or dies. I can assure you that under either scenario, the punishment he receives is a harsh one. It's one of the two harshest punishments that our law has to offer: life in prison with no parole or the death penalty. He will pay for his choices under either scenario. But now you must make a choice. And I can assure you that if putting Alan Wade to death would bring back the Sumners, I may do it myself. But unfortunately, that is not the way life works. That is not the way our fragile existence is. Sadly, there's nothing that can happen in this courtroom that can undo what happened 17 years ago. We can't undo someone else's choices, but now we have to make our own. Let me begin by saying that nothing we have offered, nothing I intend to talk about, nothing we put upon that witness stand is intended to justify or excuse anything that Alan Wade did. This is not a matter of whether Alan Wade knew the difference between right and wrong. If he didn't know the difference between right and wrong, he wouldn't be guilty of first-degree murder. Some crimes deserve the death penalty, but some defendants don't. The law requires you to look beyond the facts of the crime. Think about it. If you weren't required to look at the human being, then you wouldn't need a penalty phase. You could make your decision at the end of the guilt phase. But what the law requires you to do is to look at the human being you're being asked to execute. Because we are not, the state is not asking you to execute the person 17 years ago. The person you'll render a verdict on is the person today, the person that sits in this courtroom with us and breathes our air. The state of Florida, the laws of the state of Florida, is always satisfied with a life sentence. A life sentence is a perfectly acceptable punishment for the crime of this magnitude, and none of you are ever required to put someone to death. No one will be required at the end of this proceeding to kill Alan Wade. Nothing that I say today, or nothing that we have offered to you in the form of evidence, is meant to minimize or justify. It is not meant to disrespect the family of the victim or the memory of the Sumners. Please understand that is not the purpose of this. Alan Wade was born on May 22nd, 1987. As you heard, even when Alan's mother and father were together, he didn't receive much attention. They were busy. We heard from Alan's older sister, Trish Page. She often took him to work. He had his own locker. But at some point, Trish moved to start her own life. And by the time Alan was between the ages of 6 and 8, he was molested. And I would submit to you that when the state argues there's no evidence, there's rarely evidence of a molestation. It's a crime that happens in private. It's a crime that people are ashamed of. Around the age of 8, their house is foreclosed on. Shortly after, Frida takes Alan and the children and they move to McClenny. Abruptly, they don't tell Alan Sr. where they're going. And this is where Alan Wade's relationship to Alan Sr. essentially ends. Frida Gainey is in McClenny with the children. She's working. She works an hour away. She puts Alan's brother on the autism spectrum in charge of Alan. He's not supervised. He's alone. Andrew isn't capable of watching over Alan. And we start to see slowly the beginnings of a storm. What we see from this neglect is a little boy at this time who is hurting from the loss of his father, but there's no one there to console him. By the age of 12, Alan's dad was out of the picture almost completely. We start to see patterns in Alan's life. We see marijuana use. We see drinking. And this is not meant to justify or excuse anything. This is context. What we see is a little boy who is unable to cope with what's going on inside of him. It's a little boy who has no one to talk to guide him, to care for him, to take him through this pain. And when Alan turns 13, his world begins to crash. This is the summer where his dad was supposed to take him for a month. He never showed up. It breaks a little boy's heart. As a child, he loved his dad. They spent time together. But Alan's dad abandoned him. 13 is the same year that Frida is diagnosed with cancer. His dad is gone, and Alan Wade is afraid his mother is going to die. He's a child, and he's struggling. And this is not a justification, it's context, but what we see is a young man who doesn't know what to do with his feelings. What would any of us do? What would I do now if my mother was diagnosed with cancer? He was 13 years old, and I would submit to you that 13 is a time of changes in everyone's life. You're beginning the part where you turn from a child to a man. You've got hormones and feelings you don't know what to do with, and you add the trauma in Alan's life, and we see a storm brewing. So how does Alan react? He doesn't know how to cope. He uses drugs. His behavior gets worse. He's failing in school. He's a smart kid. We heard it from everybody. He did well up until these things started happening to him. But with this trauma in Alan's life, he copes the only way he knows how. His behavior worsens. He takes drugs. It's a vicious cycle, but it's one that gains momentum. As he deals in the only way he knows how, his mother's getting sicker. And as Alan watches his mother get sicker, he doesn't know how to cope. The only way he knows how to cope is by acting out and using drugs, which in turn affects his mother. It's a vicious cycle. It keeps happening. Alan doesn't want it to progress. His mother doesn't want it to progress, but no one knows how to stop it. When Alan turns 14, his mother's cancer is progressing. She has a mastectomy. She takes radiation therapy. Her hair falls out. She gets a wig. What we also see is Alan's life falling apart. He doesn't want to live anymore. He tries to kill himself. He's reaching out for help. His young heart doesn't know what to do with this information. And what would any of us do? But in the context of Alan Wade, his world is falling apart. It's a vicious cycle. The storm keeps going. As Alan's mom gets sicker, Alan Wade is sadder. He's afraid. We hear from people that he's afraid of losing his mom. He's afraid his mom is going to die and he's going to have no one. He's afraid of being alone. And around this time, people start to notice. This is around the time when Mr. Dobson knows that Alan is hurting. He knows that Alan's dad's not around. He knows that Alan's mom has cancer. He knows that he is a young man that needs help. They call Alan into his office, and he hears from his mom that she doesn't love him. And a little boy's heart breaks. Now, I want to talk for a moment about Alan's mom. She did a lot of things wrong. She did a lot of things right. She tried. And I don't believe for a moment that she didn't love Alan. I think she did the best she could. She was struggling with cancer, struggling alone, living in poverty, with no help from her dad. She tried, and she tried very hard, but it was a situation that no one could extricate themselves from. As Rita's cancer progresses, she's struggling with the effects of the treatments, chemotherapy, radiation. She still has to work. If she doesn't, no money comes in. Alan is alone, dealing with these issues. As Alan's ineffective coping mechanisms keep on going, the only thing he knows to do, the only thing he did, is continue to hurt and misbehave, and this has an effect on Frida, and this vicious cycle continues. It's a storm that he can't get out from. It's a storm that Frida can't seem to get out from under, I should say. And at her wit's end, she looks at Alan and she tells him, "You're killing me. Stress is causing my cancer, making my cancer worse." And a little boy's heart breaks again. Think about the guilt and the pain that would cause someone 14. Now, I submit that it might not have been false. I'm sure the way Alan was acting wasn't good for her cancer treatment. And whether it was or not, it isn't the point. The point is that this is trauma. Now, the state had a lot to say about the expert testimony that we presented. I would submit one, everyone gets paid for their work. The state attorney, the court, the defense attorneys. There's nothing improper about an expert being paid. Two, the things that the experts were talking about, the things that happened in Alan's life are real. We heard them from witnesses. We saw the evidence. We saw his school records. These things were not made up. They are real. And what the expert in trauma told you are the effects. This is not controversial. We know that trauma affects people developmentally. The juvenile brain. Dr. Steinberg talked about it. The foremost expert in juvenile brain science. Dr. James talked about it. Ladies and gentlemen, this isn't controversial, it's science. The brain is not fully developed until around 25. The scientific community does not disagree that an 18-year-old's brain isn't fully formed. 47 days prior, Alan Wade wouldn't be eligible for the death penalty. Why? Well, what we heard from the experts, and this isn't controversial, are that the adolescent brain is different in three primary ways. One, it's their decision making. Two, it's their susceptibility to peer pressure. And three, it's their capacity to change. Why is this important? And I can't say it enough, I've said it before, but none of what we're saying is meant to justify or excuse in any way his conduct. He is guilty of murder, and he will spend the rest of his life in prison no matter what happens, whether he dies from natural causes or whether he dies at the hands of an executioner. This is not why it's offered. Let me say that we are not arguing that Alan didn't know the difference between right and wrong. If he did, he wouldn't be guilty of first-degree murder. Why this is relevant? Because it's mitigation. about if you didn't know about the brain science and Alan's age, and you voted to execute him, and then someone said, did you know he was 47 days past his 18th birthday? Wouldn't that be at least a fact you'd want to know? Wouldn't you want to hear about whether his personality was fully formed, whether he had the capacity to change, whether who he was going to be the person he would eventually become? I want to talk for a moment about Michael Jackson. You heard from the state's own witnesses and from the state's own argument that Michael Jackson was the ringleader. He was the mastermind. He carried out this plan. He was 6 years older, had been to prison, criminally sophisticated, with a long history of fraud. Michael Jackson was not your ordinary criminal, and we know this. Detective Meacham, I could see where he could very easily talk these other people into doing almost anything he wanted. He tried to con another inmate into helping him escape. He successfully talked a woman into giving him an alibi. In this case, in a case of this magnitude, he talked her into giving him an alibi. He's manipulative. He's more manipulative than average. And I offer this not to say that Alan is not responsible for the murders of the Sumners. That's not the point. And when I talk about Michael Jackson, I was afraid that that's what you would think I was saying. I am not blaming Michael Jackson for Alan's crimes. He is guilty and he will die in prison. But it's relevant. It's mitigation. How did Alan get here? It's a clue. Think about the facts of the case. Michael Jackson sent Bruce Nixon, 18 years old, Alan Wade, 18 years old, into the house to blindfold the Sumners before he walked in. That's manipulation. Jackson had control of the money. Jackson had the ATM cards. Jackson gave the orders, and this comes from the state's own witness. We know this. Think about the testimony that we heard regarding susceptibility to peer pressure. Dr. James talked about studies. These are studies. When you put adolescents on a driving simulator and just have peers sitting silently in the room, they are more apt to act recklessly. And Michael Jackson wasn't sitting silently. I know that when you hear the facts of this case, they're horrifying. I will not insult your intelligence and stand up here and say the facts of this case aren't aggravated. I won't do it. And I know, as you sit here, you ask yourself, how could a human being do this? When I first got involved with this case, I had the same thought. And as I sat with Alan Wade over the years, learning about his background, I realized that there were things in his life I could relate to. There are things in his life we can all relate to. Of course, we've all had trauma. Of course, there are probably people in this jury that grew up without a dad. There are possibly people here that have been abused, and no, they don't all commit murders. But we can understand the trauma. We can understand how a teenager growing up that's been sexually abused on his own, watching his mother die with no dad around, could feel differently. As I sat with Alan Wade, I had an epiphany, and the epiphany was that he's not that different than I, or you, or anyone seated in this room. Alan Wade is not a monster. He's a human being. He cries, he cares, he deeply regrets what happened, and if he could take it back, he would. You've seen him in the courtroom. His tears aren't fake. Alan Wade is not the man that he used to be. He isn't. I could understand, in speaking with Alan Wade, how you can be attracted to the older guys in the neighborhood. When you grow up without a dad, with your mom not around, ironically, it's the guys like Michael Jackson, the guys that have been in prison, the tough guys that make you feel safe. It's why kids join gangs. It's why people are attracted to guys like this in the neighborhood, is to feel safe. That's irony. But it's something that we can understand. What I realized is that Alan is not so different than any of us, and that but for the grace of God, but for a zig or a zag, it could have turned out much differently. I could have turned out much differently. You could have turned out much differently. We are human. He is human. I would submit to you that what came together in Alan's life was in many ways the perfect storm. As his life spun out of control, as he watched his mother dying alone, as he reached out for someone to care, as he reached out for support, for shelter, for food, for money, for love, for family. At the exact wrong moment in time, in walked Michael Jackson and Tiffany Cole. And what we have is the tragedy that we have here. Bruce Nixon, 18 years old, got 45 years. I will only talk for a moment about the state's case, and I will say this. The state presented their case in aggravation to you. That case in aggravation, if Alan Wade gets the death penalty, is the justification for murder. It's the justification that the state of Florida has to kill Alan Wade. It's the justification that the executioner, the person that injects him with poison, will use to clear his conscience. When you think about the evidence you've seen, think about it. Mitigation can be anything. It can be anything from the state's case, anything that we've presented. It can come from your own sense of mercy. It can be anything, nothing at all, or your own personal moral assessment. Mitigation can be things from his childhood. It can be things from his adulthood, which has been spent entirely in prison. It could be your reluctance to take a human life. Ultimately, you are not sentencing the 18-year-old Alan Wade. You are sentencing the man as he sits here today. Now, I want to thank you for paying such close attention. I know this has been a long trial. Trust me, I'm exhausted as well. But I watched all of you and I've been taking notes. You've been asking questions. I know everyone takes this very seriously. I want to thank you for that. I could also tell by the tone of your questions that people have different opinions. People have different moral compasses. And that is exactly what the law requires. Alan Wade is entitled to 12 separate, independent moral assessments. This isn't like a guilt phase where the law encourages you to be unanimous. What the law is envisioning in a sentencing phase is that 12 of you each come up with your own verdict. The state of Florida is always satisfied with the life verdict, and if one of you votes for life, then the sentence is life. And that is perfectly acceptable. It's the way it's set up. It's an individual moral assessment, and we expect you to disagree. It's okay to disagree. It's okay because it's a moral assessment in the same way that your religion or who you choose to marry or what you choose to do in your life is your own. It's not acceptable to talk someone out of their own moral assessment. And it is your duty, your sworn duty, if you make a decision based on your moral assessment, if you have a vote for life, you have to get it on that verdict form, or there will be a miscarriage of justice. You cannot be talked out of it, you cannot be bullied, and I trust that none of you will. If you decide to vote life for Alan Wade, once you've made your decision, you don't have to explain it, you don't have to justify it, you don't have to tell anyone what it is, and you'll never be asked what your vote was. You may be asked, but you don't have to speak about it. Once you've made your decision, if you've made your decision, you don't have to say another word. You can knock on the door and tell the bailiff you're done, because you're done. It's not a group factual decision like a jury on a guilt phase case. You're not being asked to all come to the same conclusions. Ladies and gentlemen, you are being asked to make a God-like decision on whether someone lives or dies. But without God-like wisdom. You are being asked to execute another human being. And if you have even the slightest reluctance or the slightest thought that in 10 years you may regret your decision to kill Alan Wade, then that is a reason to sentence him to life. You do not have to kill Alan Wade. You don't have to. Life is an acceptable punishment. The state is always satisfied. The laws are always satisfied with a life verdict. You never have to vote for death. Not in this case, not in another case, not in the worst case you can possibly imagine. Life is always an appropriate sentence. It's life in prison without parole, and it's a harsh sentence. If you execute Alan Wade, you're executing the little boy whose dad didn't show up in the summertime. You're executing the little boy whose mother had cancer and blamed it on him. You're executing the kid that was thrown out on the streets, had no place to go. You're executing a son, an uncle, a father figure to Jade. Mitigation can be anything. It can come from what you've seen on the stand, from the state, from us. It could be the look in his mother's eye. It could be your reluctance to kill anymore. It could be your belief that there's been enough killing. It could be your own sense of mercy. And ultimately, the decision you're going to be asked to make is about Alan Wade, but it's also about you. It's about your decision and what will stand the test of time with your own moral compass. Some crimes deserve the death penalty, but some inmates do not. If you vote to execute Alan Wade, one day you'll open up the newspaper and you'll realize, you'll read that Alan Wade has been executed. The state of Florida has strapped him to a gurney, injected him with poison until his heart stops and a human being takes his very last breath. And if you have the slightest hesitation or doubt that you will look back and wonder if you did the right thing, then that is a reason to vote for life, and you are empowered to do so. But what I can promise you is this, that you will never regret not killing Alan Wade. Ladies and gentlemen, we're getting close to the time where I sit down. It's going to be handed to you. While you're thinking about this decision you're being asked to make, I want to point out a couple of things. Alan Wade did well when he had structure. Alan Wade did well when he was with Teresa Rowe. Think about it. It is mitigation. It's mitigating because we know that when Alan had the right kind of structure, he did okay. Had Teresa Rowe kept him under the watchful eyes of a healthy family, we wouldn't be here. Perhaps. When he was with Trish up north in the Sumners, he was a good kid. He did okay. He followed his curfew. Had he had the structure he needed, perhaps we wouldn't be here. Alan Wade, since his arrest, since his incarceration, for the 17 years he's been in prison, never been violent, minimal disciplinary reports. He's been a father-like figure to Jade. He's reconnected with his family. With the structure that he has, Alan Wade thrives. He can thrive. He's capable of thriving. And I say that because Alan Wade is a human being. He's salvageable. The death penalty is reserved for the truly irredeemable. Alan Wade is not the truly irredeemable. Ladies and gentlemen, as we stand here today, all we are asking is for your meaningful consideration of the things you've seen today. We're not asking you to save Alan's life because he was molested. We're not asking you not to vote for death because he had a traumatic childhood. We're not asking you not to execute him because Michael Jackson exerted pressure on him. We are not asking you not to execute him because of the things that happened to him. We are asking you to consider all of these as they came together in Alan's life as the perfect storm. And for you to give mercy. Thank you.
All right, thank you, Mr. Johnson. Members of the jury, if you'll step back in the jury room for just a few moments, for just a short break. All right, the jury has left the courtroom. I've got to step back to the back for a moment to get my notes. Where's the packet of, yeah, why don't you go ahead and give those to the bailiff and,
You know, we attached the preliminary instructions.
I can,
We attached the preliminary instructions on top too. I thought the court wanted to give them everything.
no.
Okay, let me sort of rip the preliminary.
Yeah, I mean, I did that up here, just a packet that starts with the final note. They don't, it's only the instructions, not copies of the verdict form, right?
Correct, it's just
Okay.
the instructions.
Okay, if you go ahead and address that, I'll be right back. We'll be in a short break. 5 or 6 minutes. So, doing this, somebody's going to bring it up and.
Everybody has a copy of the final. You remember we subbed it, alternate one on the jury, panel one, alternate two.
Take the court's in session.
Ms. Miller, the instructions which you've given me, you have gone over them in your brief.
Yes,
Subject to objection from yesterday.
yes,
And is that also true of the verdict?
yes. Subject to our objections.
Yes.
And I think Mr. Mizrahi and I should agree that the two alternates are Campbell and Beck.
Campbell and back.
Campbell and Pat.
Yep.
Okay. And I will tell them that when I release them again.
Yes.
All right, are we ready to proceed then, Mr. Mizrahi?
Yes, sir.
Mr. Moore, okay. Go ahead and have the gallery come in, please. Almost. Here we go. Go ahead and let the public in. No, everybody want to listen to you, nobody want to listen to me, huh? Is that what it is?
Some of the family is not coming.
Okay. All right, well then, as soon as we come close to, all right, if the jury's ready, have them join us, please. All right, the jury has returned. Be seated, ladies and gentlemen. Members of the jury, we are now at the phase in which I will explain to you, perhaps summarize is a better word, some of the matters which you've heard today here. I have provided for you a copy of the general instructions, including some lists of stuff that I'm going to ask that you consider during the deliberations. I'm giving it to you. I'm going to be paraphrasing some of this so you can, if you feel necessary, you can read along. If you can't understand what I'm saying, you're going to read along. Otherwise, I've got those there mostly for you all to use during the course of your deliberations because some of it is fairly voluminous. There's some lists which are significant. You have now heard all of the evidence and the argument of counsel, and it's now your duty as a jury to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crimes of first-degree murder. There are two possibilities of penalty: life imprisonment without the possibility of parole, and death. Now, in making your, and by the way, I've broken this down in the aggravator, we'll talk about the aggravators and then the mitigators, and then there's some general instructions about how you assess the evidence which you have heard, and then I will conclude with some fairly specific instructions about how you should administer your deliberations. So that's sort of the outline format. You have heard us say before, and I will say again, in making your decision in this matter, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. Now, as I have suggested before, an aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. You may not consider anything other than the facts which have been provided for those aggravators to decide whether or not they've been provided in support of the death sentence. You are limited to the evidence which you have heard pertaining to those aggravators. Now, in this particular matter, the state has alleged these aggravators, and I will try and explain some of them to you. The first being that Mr. Wade was previously convicted of another capital felony. The crime of first-degree murder is a capital felony. Mr. Wade was found guilty of two counts of first-degree murder, and those convictions occurred prior to this proceeding. You know that. The second is that the first-degree murder, as I say murder, we are talking about two, the death of Carol and of Reggie Sumner. The first-degree murder was committed while Mr. Wade was engaged in the commission of a kidnapping. Mr. Wade has also been found guilty of two counts of kidnapping. The third aggravating factor is that the first-degree murders were committed for the purpose of avoiding or preventing arrest. The first-degree murders were committed for financial gain. The first-degree murders were especially heinous, atrocious, or cruel. Now, heinous is a word of art which means extremely wicked or shockingly vile. Atrocious means outrageously wicked and vile. Cruel means that it's designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Carol and or James Sumner. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Now, cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit the murder. Now, in the law, we say killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. Now, the law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. Now, the premeditated intent to kill must be formed before the killing. Now, however, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. The term pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. The last aggravating factor is that Carol and or James Sumner were particularly vulnerable due to advanced age or disability. Now, you have heard evidence about the impact of this murder on the family of Carol and James Sumner. as I mentioned to you when it was introduced, the evidence was presented to show the victims, plural, uniqueness as individuals and the resultant loss by Carol and James Sumner's death. However, you may not consider this evidence as an aggravating factor. It's simply there for your information. You may not consider this evidence when you decide whether the aggravating factors are sufficient for the death penalty, or when you weigh the aggravating factors against the mitigating circumstances, or, of course, when you make your final decision on the appropriate penalty. As I think I explained before the presentation of the evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. Now, a reasonable doubt is not a mere possibility. It's not a doubt based in possibility. It's not a doubt based in speculation. It's not based in imagination. It's not something that you have to force. Those kinds of doubts must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you don't have an abiding conviction that the aggravating factor exists, or if you think you have a conviction, but whatever it is not stable, but it wavers and vacillates, then in those instances, the aggravating factor has not been proven beyond a reasonable doubt and you may not consider that in providing your verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, from conflict in the evidence, or it may even arise from the lack of evidence. Perhaps simply stated, members of the jury, if you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Now, again, a finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. Now, I will provide you a verdict form in which you can document this conclusion as to each of the aggravating factors, and you will be required to indicate whether or not you find that those aggravators have been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. If you get to that point, your deliberations are over. If, however, you do unanimously find that one or more of the aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without parole or death. If you do unanimously find that the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose a death sentence, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It's not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character or background or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in the case. Now, it's the defendant's obligation to provide for your consideration that mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, They only need to be established by the greater weight of the evidence, which means that more likely than not, I'm sorry. Instead, the defendant need only establish a mitigating circumstance or the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of the mitigating circumstance, more likely than not. If you determine by the greater weight of the evidence that a mitigating circumstance does exist, you must consider it established and give that evidence such weight as you determine it should be received in reaching your verdict about the appropriate sentence to be imposed. Any of you, any individual juror persuaded as to the existence of a mitigating circumstance must consider in this case. Now, among the mitigators which have been suggested, Mr. Wade has no significant history of prior criminal activity. He was under extreme duress or under the substantial domination of another person. The capacity of Mr. Wade to appreciate the criminality of his conduct or conform his conduct to the requirements of law was substantially impaired. The age of Mr. Wade at the time of the crime. Mr. Wade was neglected and abandoned by his parents during his early childhood. Alan Wade has a family history of mental illness, including but not limited to depression and substance dependency. Alan Wade's babysitter touched Alan's penis when she babysat Alan between the ages of 6 and 7 years old on several occasions. Mr. Wade's brother Andrew's friend, Sean Adair, performed oral sex on Alan and touched his penis when Alan was between the ages of 6 and 7 years old. He also forced Alan to perform oral sex on him. Mr. Adair told Alan they had to do it before they could play. Alan Wade began banging his head into walls at 5 years old to the point that the members of the First Assembly of God in Daytona Beach attempted to exorcise him of demons by pressing on his chest similar to CPR and slamming his head on the floor when Alan was between the ages of 6 and 7 years old. Mr. Wade's pastor's son at the First Assembly of God in Daytona touched Alan's penis and forced Alan to touch his penis. He was an adult man. When Alan was between the ages of 7 and 8 years old, he would pin Alan against the wall and forcefully touch and kiss him. Mr. Wade was frequently jumped and beaten by his peers when he lived at the Water Club apartment complex when he was between the ages of 5 and 7 years old. Mr. Wade's mother, Frida Gainey, abruptly moved herself, Alan and his brother, Andrew, from Daytona Beach to McClenny when Alan was 8 years old. Alan Wade grew up in poverty. Alan Wade was abandoned by his father, Alan Wade Sr., who rarely paid child support or visited his children. Mr. Wade was particularly distraught at the idea of his mother giving the family's ping pong table to the church because it was his last and only reminder of his father. Alan Wade's mother was diagnosed with breast cancer when Alan was 13 years old. Mr. Wade's mother was unable to parent Alan because of her own battle with cancer, while simultaneously raising Mr. Wade's brother Andrew, who is on the autism spectrum. Mr. Wade's mother told him while standing in the driveway that stress gave her cancer and that he was her main source of stress. She then kicked him out of the home when he was 13 years old, stating, "I think it would be best if you leave." Mr. Wade was kicked out of his family home on multiple occasions prior to his mother's cancer diagnosis and experienced months of homelessness when he was 12 and 13 years old. He lived with friends in an abandoned jail and in the woods. Mr. Wade confided in Assistant Principal Brian Dobson that he did not believe his mother loved him. Mr. Dobson called Mr. Wade's mother with him on the phone and asked her to tell Mr. Wade that she loved him. She told Mr. Dobson, with Mr. Wade listening, that she could not say that she loved her child. Mr. Wade's mother sent him to stay with his half-sister, Patricia Trish Page, in Connecticut during the summers when Alan was 11, 12, 13, and 14-year-olds so he could spend time with her and in the hope that he would stay out of trouble. Mr. Wade also stayed with his brother Robert, 15 years older than him, and his wife Nikki in Massachusetts the summer Alan turned 14 years old. Mr. Wade's mother asked Nikki if Mr. Wade could stay with them permanently, but she said no because of her concerns regarding Robert's drug abuse. Mr. Wade's mother began a romantic relationship with Jerry Gainey in 2000. However, Mr. Gainey had no interest in being a father or father figure to Alan. Mr. Wade wanted to die and threatened suicide when he was 15 years old. After threatening to kill himself and fleeing from school, he was pursued by law enforcement in the neighborhood, where he was ultimately caught and placed under involuntary mental health hospitalization, also known as the Baker Act. Mr. Wade used drugs and alcohol extensively as a coping mechanism because he hated himself and his life. He drank alcohol daily at 11 years old. He first smoked marijuana at 12 years old. He first used cocaine at 13. He has also abused Xanax, Percocet, methadone, hydrocodone, oxycodone, and other pills. Mr. Wade began struggling in school when he was 12 years old, forcing him to repeat the 6th grade twice and the 7th grade once, due to poor attendance and failure to complete assignments. Mr. Wade and his friends played the choke-out game, where they would take turns choking each other to the point of unconsciousness, beginning when Alan was between 12 and 13 years old. Mr. Wade dropped out of school before completing the 9th grade. Mr. Wade's descent into serious drug use and truancy directly coincided with his mother's declining health from cancer. Mr. Wade was again hospitalized pursuant to a Baker Act in 2003 when he was 15 years old. He was then committed to Gateway Community Services for mental health issues, including specifically substance abuse. Mr. Wade's friend's mother, Teresa Roden, offered to take guardianship over Mr. Wade in 2003. However, Mr. Wade's mother was unwilling to contribute financially to Ms. Roden, so Mr. Wade was forced to return home. Mr. Wade's mother threw him out of the house and changed the locks when he was an adolescent, leaving him homeless. On one such occasion, Mr. Wade called Teresa Roden for help. She found him on the front lawn with all of his personal belongings in garbage bags. Mr. Wade thrived while living in a structured environment with his half-sister, Trish Page, and with Teresa Roden. His mother would not allow Mr. Wade to move into her new apartment, with her leaving him homeless when he was 17 years old. Mr. Wade's friend William Davis died by suicide when Mr. Wade was between the ages of 16 and 17 years old. Mr. Wade had a reckless disregard for his own personal safety, doing things that may have resulted in a personal injury or his own death, as long as there was someone to watch. Mr. Wade earned his GED when he was 17 years old. He attempted to join the Army National Guard when he was 17. Mr. Wade experienced toxic stress from exposure to adverse childhood experiences. Mr. Wade's life theme as a child and adolescent was described as looking for guidance and looking for acceptance. Mr. Wade found his guidance and mentorship he was searching for from Michael Jackson when he was 17 years old and Michael Jackson was 22 years old. Mr. Wade was provided drugs, money, and a place to live by Michael Jackson. Michael Jackson manipulated and influenced Mr. Wade into doing his bidding. Mr. Wade was afraid of Michael Jackson and afraid Michael Jackson would hurt his mother. Michael Jackson pulled a gun on Mr. Wade. Mr. Wade's brain was not fully formed or matured at 18 years old. As an 18-year-old, due to his stage of brain development, Mr. Wade was more likely to act on impulse and engage in dangerous or risky behavior, and was likely to think before he acted, pause to consider the consequence of his actions, and change his dangerous or appropriate or inappropriate behaviors. Mr. Wade's use of drugs and alcohol as a young adolescent further impeded his brain's growth and maturation, contributing to cognitive impairment of certain functions. Mr. Wade's life at the time of the murders of Reggie and Carol Sumner was the perfect storm of adverse childhood experiences, plus drugs, plus his adolescent drag, plus exposure to Michael Jackson. Mr. Wade has been a model prisoner since incarceration at the 18 years old with only minimal disciplinary infractions. Mr. Wade again studied for and took the test, earning his GED for the second time while incarcerated in jail. Mr. Wade served as a tutor in the GED program in jail. Mr. Wade primarily spends his days in prison reading and attempting to better himself however he can. Mr. Wade has served as a mentor and big brother figure to his older brother, Roberta's daughter, Alyssa Jade Craig, while in prison. Mr. Wade, now at 35 years old, wants to embody the virtues of integrity, love, and respect. At 18 years old, Mr. Wade's perspective of himself was that he was homeless, worthless, reckless, and not good enough to live. And Mr. Wade is profoundly remorseful for what he did. Mr. Wade is loved by his families and friends. And those are the mitigating circumstances suggested by the defense. Now, sorry, bear with me again. Your decision regarding the appropriate sentence in this matter should be based upon the proven factors and established mitigating circumstances that have been presented to you during the proceedings. Now, the next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found to exist outweigh the circumstances that you have individually found to exist. The process of weighing aggravators and mitigating circumstances is not mechanical, it's not mathematical. You should not merely total the number of aggravating factors and compare their number to the total of mitigating factors. That's just not how we do it. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. You may always consider mercy in making this determination. Now, once each juror has weighed the proven factors, then he or she must determine the appropriate sentence appropriate punishment for the defendant. The jury's decision regarding death must be unanimous. You're finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision to impose a death sentence must be unanimous. Now, as I think I mentioned earlier, I will provide a verdict form for you and we'll talk about it actually in a moment, to record the decisions. If your vote on the appropriate sentence is less than unanimous, then the sentence will be life in prison without possibility of parole. Now, you are being asked to consider the sentence for 2 counts of first-degree murder. And although we have tried them or you have heard all of the evidence together, you need to actually assess each sentence separately. And you must consider separately and a separate verdict returned as to each death. Whatever findings that you may find, findings regarding aggravators and mitigators that you may find as to one count must not influence your verdict as to the other. And it is a separate analysis. I realize everything's been conjoined, but it is actually a separate analysis. And in fact, I have prepared 2 verdict forms, one to cover the death of Mr. Sumner and one to cover the death of Mrs. Sumner. I know I probably don't need to mention this, but I have put it in the instructions. The fact that you can make this weighty decision based on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict in this matter. When considering aggravating factors and mitigating circumstances, it is up to you to decide what evidence is reliable. You should use your common sense in deciding what is the best evidence and which evidence should not be relied upon by you in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence in the case. Now, I would suggest that you should consider how the witnesses acted as well as what they said. Here's some questions you might pose to yourselves. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest, straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony, other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Has the witness been convicted of a felony or of a misdemeanor involving dishonesty or false statement? In talking about the witnesses, let me mention the fact that the witness is employed by law enforcement doesn't mean that his or her testimony deserves more or less consideration than any other witnesses. They are to be treated equally. But let me mention expert witnesses because we have a few. I'm sorry. Expert witnesses are like other witnesses, all of them, with one exception. And that is that the law permits an expert to give an opinion about something. However, an expert's opinion is only reliable when given on a subject about which you, the jury, believe him or her to be an expert. Like any other witness, you may believe or disbelieve all or any part of the testimony of any of the expert's witnesses. It's entirely up to you. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime or hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So, while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of the other witnesses. I might point out also, it's entirely proper for the attorneys to talk to witnesses about what their testimony would be once they're called to testify in the courtroom. So the fact that you have learned that any of those conversations have existed or occurred outside of the proceedings is not something that you should use to discredit that witness testimony. It's what they're supposed to do, and don't even talk about it. You may rely upon your own conclusions about the credibility of any of the witnesses. You as a jury or a juror individually may believe or disbelieve all or any part of the evidence or the testimony of any of the witnesses which have taken the stand during these proceedings. I'm sorry, I'm slowly losing it. There are some general rules that apply to your deliberations. You must follow these rules in order to make a lawful decision. You must follow the law as I have set it out in these instructions. If you fail to follow the law, your decisions will be a miscarriage of justice. There's really no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and therefore a legal decision in this matter. Your decisions, again, ad infinitum, ad nauseum, must be based only on the evidence which you have heard from the testimony of the witnesses, seen in the form of the exhibits, heard during the course of the proceedings, and of course these instructions. Your decisions must not be based upon the fact that you feel sorry for anyone or because you are angry at anyone. Please remember, talking about the lawyers a minute ago, that the lawyers are not on trial. Any feelings that you may have developed about them should not in any way influence your decisions. Why not? It's not evidence. So whatever may have developed, if any, please do not discuss it. Please base your verdict only on what you've heard from the stand. I mentioned once or twice during the course of this that you're not to, the juror questions, I did not ask some juror questions. Please do not discuss that. There's no reason for you to discuss it. It's not evidence. My failure to do something is not evidence. The only evidence which you've heard from the stand. So don't make any deductions about a question I might have not have posed. Some of you are taking notes and some of you did. Let me go back and talk to you about the notes again. Please remember what I told you. The notes that you have taken are for your individual recollections, and that alone. I'm not going to tell you can't use them. That would be silly for me to tell you to take notes, but you can't use them back during the deliberations. What I am going to tell you is you may not let your own notes become the focal point of deliberations, nor will you let another juror's notes become a focal point of deliberations. They are merely there to refresh the recollection of the note taker. And I think I mentioned early on the main reason for not letting them become part of the deliberation is they could be wrong. Your responsibility is to return collective analysis, fairly and impartially, and individual assessments once you've gotten to that point. So don't let the notes become an issue for you. Your decision should not, of course, be influenced in any way by prejudice or racial or ethnic bias. Your decision must be based solely on the evidence and the law in these instructions. Let me mention briefly, I'm not going to go into great detail, but we've talked about the use of the phones. You may not have your phones during the course of deliberations. And the reasons for that, I've tried to explain it a couple of times now, and I'm sure all of you understand. So what I've done is, I believe, are the envelopes back there? They are back in this. What I'm going to ask that you do is if you will make sure your name is on the envelope, put your phone in the envelope, clip it, and let the bailiffs take it, and as soon as you have, returned a verdict, then, be returned to you. There's a secure spot that we have here in the courtroom that will take care of it. During the course of deliberations, you are required to only discuss the evidence when everybody is present. If someone needs to take a break, stop. Why is that? You might miss something. Your deliberation is to be, again, a collective analysis of some of this and individual assessment of the evidence. So when you deliberate, make sure everybody's present while you're there. So everyone else can have the benefit of everyone else's thoughts. You're going to have to come up with a unanimous decision, as I have explained to it, or not. And it's a careful analysis that you have to do. There were a number of exhibits that were introduced. They will be out here in the courtroom, and if you want to use any of them or see any of them, just let us know and we'll bring them back. Let me say at this point that I am precluded by the canons of professional ethics and the canons of judicial ethics to participate in your deliberations or offer any comments or anything like that. Now, the reasons for that should be obvious. So I say that if you think that I have come to any conclusions or said anything or have any particular preferences about any of this, whatever it was, it's not true. I have no concerns about the outcome of this because I have 12 of you to make that decision. So if you think that I have any feelings, whatever it was, again, fourth time, fifth time, it's not evidence. The only evidence is what you're going to hear from the witness stands. Now, in just a few moments, I'm going to ask you to step back and begin. Well, I'm going to talk to you about the verdict form first. Let me do that. I have only 2 copies. I can't afford, you do not have this. I have the only 2 copies, and the reasons for that, well, I'll talk about that. I'll go through one of them. I have an identical form for the death of Mr. Sumner and one for the death of Mrs. Sumner. It is a sort of an instructive, interrogatory sort of thing. I'll walk you through it. It starts off at the top with what we call the style of the case. Case number, Circuit Court of the State of Florida, that's where we are. This is the Circuit Court. There's a case number, there's a division, that's me. The State of Florida versus Alan Lyndell Wade. If after carefully considering this, analyzing this, all of your deliberations, when you have gotten to the conclusion of all of this, then you must record the results of your deliberations. And the first line says, we, the jury, find as follows as to Alan Lyndell Wade in this case. Paragraph A, aggravating factors as to count 1, Carol Sumner. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to Alan Lyndell Wade in this case. Paragraph 1. Alan Lyndell Wade was previously convicted of another capital felony. Yes? No. Was it unanimous? Yes. If it was not, no. The second question, the first-degree murder was committed while Alan Lyndell Wade was engaged in the commission of a kidnapping. Yes or no? Unanimity or not? The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. Yes or no? The fourth, the first-degree murder was committed for financial gain. Yes or no? 5. The first-degree murder was especially heinous, atrocious, or cruel. Yes, unanimous, no, not. 6, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes or no? Carol Sumner was particularly vulnerable due to advanced age or disability. Yes or no? Now, those are the aggravating aggravating factors that have been listed in this manner, and that's how you're going to record your decision, unanimous or not, as to each of those. There's an instruction. If you answer yes to at least one of the aggravating factors listed, please proceed to section B. If you answer no to every aggravating factor listed, do not proceed to section B. Mr. Wade is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. Again, at least one aggravating factor must be established unanimously. Section B, the sufficiency of the aggravating factors as to count 1. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible death sentence, sentence of death. Yes or no? If your answer if you answer yes to Section B, then you would proceed on to Section C. And of course, if your answer is no, then that ends it. Mr. Wade would be sentenced to life in prison without possibility of parole. So once you have determined that he is eligible, then you go through the recording of the weighing of the mitigating factors, mitigating circumstances. And this one says one or more individual jurors find that one or more mitigating circumstances was established by the grade of the weight of the evidence, yes or no. And then proceed on to D. We, the jury, find unanimously that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 1. Yes or no? Again, it's a unanimous decision. You must make that decision unanimously. If you answered yes to Section D, then you proceed on to Section E. If you answered no, of course, then Mr. Wade will be sentenced to life in prison without possibility of parole. And then paragraph E is jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, that the aggravating factors are sufficient to warranted. I'm sorry. Let me read it again. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factors are sufficient to warrant a sentence of death, and the aggravating factors outweigh the mitigating circumstances, we, the jury, unanimously find that Alan Lyndell Wade should be sentenced to death. Yes or no? If your vote is no, then I'm asking you to record the numerical count in the next paragraph. If your vote to impose death is less than unanimous, then I will impose a sentence of life without possibility of parole. In both of the verdict forms, there's a place for the foreperson foreman to sign and to date the verdict forms. And as I have said, the questions are identical. The law requires a separate analysis by you. So we have two separate verdict forms that will go back with you. When you do get back in the back, the first thing you will need to do is to select a foreman, foreperson, chairman, I'm not sure, we call them forepersons these days, I guess, but whatever you want to call that person, it's that person's responsibility once you have made that selection to preside over your deliberations like the chairman of any committee that you might have been involved in at work or church or school or that sort of thing. It's also that person's responsibility to sign, to fill in and sign and date the verdict form when you have reached a verdict in this matter. Any one of you can be the foreman, foreperson. It's entirely up to you. That's just a decision that you all have to make to decide how you're going to proceed in this. Now, in closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this particular case. Even if you don't happen to like what I have told you, it is nevertheless the laws of the state of Florida, and you have taken an oath as a juror to follow these laws. Nobody has the right to violate the rules or the laws that all of us are expected to abide by. That said, I will tell you at this point that I'm sorry, counsel, Ms. Campbell and
Ms. Campbell and Ms. Batten.
Ms. Batten. Ms. Campbell, Ms. Batten, turns out that y'all two were the two, I don't remember who's who, but anyway, the two of you, the two of you were the alternate jurors. So if you will step down, do you have any personal effects back there in the back, either of you? If you'll go ahead and step back and get those, and then come back out here to the courtroom. Any additions or go ahead, let them step in the back.
Your Honor, the state is asking that the state exhibits as well as the defense exhibits go back with the jury.
Okay, that's fine. Sure.
And we have a laptop that can clean the defense has seen and play the two audio.
Oh, okay, that's fine. Sure. You'll understand. You will have the physical evidence back there and a laptop if you want to listen to the disc. So, Ms. Batten and Ms. Campbell, if y'all will go ahead and get your personal effects and maybe your lunch. I have no idea whether yeah, just go ahead and leave your notes there and we'll collect them shortly. Any additions or corrections other than previously noted, Mr. Mizrahi?
No, Your Honor.
Mr. Johnson?
No, Your Honor.
Members of the jury, you may now retire to consider your verdict. Just going to get Jeff to tell him this on the way. Have Ms. Batten and Ms. Campbell come back out, please. All right, the jury has left the courtroom. The time is 12:25 p.m. We will await the verdict. I understand that the food has been ordered, but it is not quite here yet. So, I know, what a surprise. y'all will stand by until the alternates come out, please. Go ahead and have a seat, folks. I just want to. She is bringing them out, isn't she? I guess. He is getting Miss Campbell out, isn't he? Okay. I'm sorry?
One of the jurors has requested a smoke break.
Where can they smoke?
I don't know.
Well, back on the record, staff indicates that one of the jurors wants to take a smoke break. Well, I know that you might agree. No, you don't smoke. I'm thinking of,
I think the court can, since we have not really begun the process of how to receive these, there was something we call not self-deliberating in the one charge. If the defense is.
okay.
Technically, they're supposed to stay together once deliberations have started, so maybe there is some.
Well, let me tell them to come out here and just tell them not to start talking yet until we, okay. Just, yeah, have them, see if they've elected a foreman. Yeah. Well, then have the panel come out here and just stand out here for just a minute. Okay. Speaking of drug addictions. Oh, update on the lunch.
Jurors are ready.
Yeah, just. Yeah, y'all just come out here. It's easier for me to just, talk to you in a group. Yeah, just kind of fill the void here. Okay, we got 12. Remember I told you that you have to discuss everything where everybody else is present. One of you apparently needs to step outside and have a smoke break. And I'm willing to accommodate that. But that means that if that person's going to have to go with one of the officers out to wherever you can do it outside, I don't know, I quit 20 years ago, so I have no current frame of reference. But that means that you may not begin the deliberations until that person has returned. I mean, perhaps you can go ahead and select the foreman if you want to. It's my understanding that the lunches are generally on the way. So if you, with that understanding, and I must say that at this point, once you have begun the deliberations, we cannot break until you've reached a verdict. So there won't be any, I don't know who the smoker is, but I cannot allow any further smoke breaks because it would break up the deliberations, and that's just not permitted in the way we do things. So, okay, if y'all go ahead and resume your positions back in the jury room, you'll know when you can start. Who is it? You know who it is? Okay. All right. Ms. Campbell and Ms. Batten. Folks, go ahead and sit down. I want to thank you personally for your involvement in this. I know none of this is easy, and I mean, we understand that. You were randomly, and I do mean randomly, selected on, actually, I guess it was Wednesday, to be the alternate jurors in this matter. Had anybody in the jury taken ill or had a problem or had been sick, you never would have known that you were the alternate juror. I mean, you just gone ahead and participate. Given the nature of this thing, this sort of thing, and the fact that we knew there were going to be several days, we thought it appropriate to have two alternates. So that's where you came in, and so we are all appreciative of your participation in this, particularly since you don't actually go to the goal line, as it were, in the matter. I have told you several times now not to discuss the case with anybody. I can now tell you you are free to discuss your participation in this case with anybody that you want to. You are equally at liberty to refuse to talk to anybody about your participation in this matter. It's entirely and exclusively up to you, with one exception. And I think I may have mentioned this early on. There are a few incredibly limited instances in which I, as the presiding judge, might have some legal responsibility for questioning jurors about the deliberation process, not the vote itself, but the process. That almost never happens. But that would be the one instance in which you might actually be asked to talk about your deliberations. Anything else, it is entirely up to you, ladies, to make that decision. So that said, thanks very much for your time. Please have a pleasant afternoon. We really appreciate it. Thank you. Former alternates have now left the courtroom. Anything further from the state or the defense? We will be in recess until we await the verdict of the jury.
session. You may be seated.
We are in the courtroom. The time is 4 p.m. Mr. Wade is present as our counsel. I have been advised that we have a verdict. Mr. Mizrahi.
He's ready to go.
I would assume that the clerk will publish the verdict, that there will be a polling of the jury, perhaps.
There's a standard polling instruction now, depending upon what the verdict is.
What would I say other than,
In the event of it, in light of where, if you say we wanted the jury, but that's if we get it.
Right, there's two different polling instructions.
all right, well then let's just wait and see what it is. And, well, we'll just leave it at that. Have the jury join us, please.
Jurors entering the courtroom.
All right, the jury has returned. These sitters, ladies and gentlemen. I understand the verdict. All right, the verdict form appears to be in order. Madam Clerk, please call me the verdict. Ladies and gentlemen, hearken to your verdict.
The Circuit Court, 4th Judicial Circuit, in and for Duval County, Florida, case number 16, 2005, CF 10263BXXX, Division CRB, State of Florida versus Alan Lyndell Wade. We, the jury, find as follows as to Alan Lyndell Wade in this case. Aggravating factors as to count 2, James Reginald Sumner. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to Alan Lyndell Wade in this case. Number 1, Alan Lyndell Wade was previously convicted of another capital felony. Number 2, the first degree murder was committed while Alan Lyndell Wade was engaged in the commission of any kidnapping. Number 3, the first degree murder was committed for the purpose of avoiding.
Leslie, go ahead.
Number 3, the first-degree murder was committed for the purpose of avoiding or preventing lawful arrest. No. Number 4, the first-degree murder was committed for financial gain. Yes. Number 5, the first-degree murder was especially heinous, atrocious, and cruel. No. Number 6, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. Number 7, James Reginald Sumner was particularly vulnerable due to advanced age or disability. Yes. Reviewing the aggravating factors that were unanimously found to be established beyond a reasonable doubt, Section A, the jury unanimously find the aggravating factors are sufficient to warrant the possible sentence of death. Yes. C, mitigating circumstances, one or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. D, eligibility for the death penalty for count 1, the jury unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section A, outweigh the mitigating circumstances established. Section C, as to count 1, no.
Members of the jury, I'm going to have to ask you to step back in the back. There is some answers that will very end that need to be responded to. It didn't finish the last paragraph.
They're not supposed to do the last paragraph. They don't find the end of step 4.
Should I misread it again?
If no, and you raise the vote. That's
And
only,
there's a place for the vote.
that's only if they get to step 5. They only do a vote on step 5. So they just answered no, they do not find the aggravators outweigh the mitigators, so the verdict is left. They're done. They don't go to step 5. I was trying to. Here's Aaron.
Yeah, I would come back, give it a good one. All right, the jury is returned. Be seated, ladies and gentlemen. I may have misinterpreted my own jury verdict form. It's been a long week, sorry. Okay. All right, that concludes the reading of the verdict as to the death of Mr., I'm sorry, what did you read? Okay. proceed.
The jury finds as follows as to Alan Lyndell Wade. In this case, A, aggravating factors as to count 1, Carol Sumner. B, the jury unanimously find the state has proven that the following aggravating factors beyond a reasonable doubt as to Alan Lyndell Wade. In this case, 1, Alan Lyndell Wade was previously convicted of another capital felony. Yes. Number 2, the first-degree murder was committed while Alan Lyndell Wade was engaged in the commission of any kidnapping. Yes. Number 3, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. No. Number 4, the first-degree murder was committed for financial gain. Yes. Number 5, the first-degree murder was especially innocent persons in full. No. Number 6, the first-degree murder was committed in a cold, calculated, and premeditated murder without any pretense of moral or legal justification. Yes. Number 7, Carol Sumner was particularly vulnerable due to the advanced age or disability. Yes. Sufficiency of the aggravating factors as to count 1, reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we the jury unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. C, mitigating circumstances. 1 or more individual jurors find that 1 or more mitigating circumstances established by the greater weight of the evidence. Yes. Eligibility for the death penalty for count 1, we the jury unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established Section C. As to count 1, no. Dated the 16th day of June 2022 in Duval County, Florida, signed the court person.
All right, thank you, Madam Clerk. Any polling for the jury?
No, Your Honor.
Any reason the sentence should not now be imposed?
No, Your Honor.
Mr. Wade, if you'll step to the bench, please.
Your Honor, just confirm there's no victim impact.
I'm sorry?
Let me confirm there's no victim impact. I just want to make sure that there's no additional risk to victims.
Okay.
For their constitutional right, I assume no victim impact? No victim impact, we're done? We can get sentenced to life right now?
Okay, Your Honor.
Mr. Wade, step to the bench. Mr. Wade, you have previously been found guilty by a jury of your peers of the homicides of Carol and Reggie Sumner. Another jury of your peers having found that you should be imposed, that a sentence should be imposed against you should be life imprisonment, but not death. I hereby impose that sentence. I will remand you to the custody of the Department of Corrections of the state of Florida to remain in custody for the remainder of your natural life. If you believe there's anything illegal about this sentence or this trial, you have 30 days within which to appeal.
Your Honor, I ask those sentences one consecutive.
I'm sorry?
I ask those sentences one consecutive.
That would not be inappropriate. I would do so. All right.
Your Honor, he has 904 days of previous credit plus his 46 prison time and 1,872 days.
All right, he's entitled to that credit for time served. Take him down. Members of the jury, you have now concluded your obligation for the summons which brought you in here this week. I can only tell you that all of us who regularly work here in this system, appreciate the commitment that you have made to participate in this now almost 2 full weeks. We understand that none of this is simple, and we understand the importance and the impact that your decision has made today. For 2 weeks now, I have told you not to talk about this with anybody. I will now tell you, you have the absolute right to discuss your participation in this trial with anybody that you want to. You have the equally absolute right to refuse to discuss your participation in this trial with anybody that you want to, with one minor exception. I think I mentioned this earlier last week, and that would be there are limited instances in which I, as the presiding judge, might be required as a matter of law to ask you questions about the deliberation process. No one will ever question your verdict, but there might be something like that. It almost never happens, but I feel compelled to tell you that that is a chance. In any event, you are free to talk about it with anybody that you want to or not. With my thanks, please have a pleasant afternoon and evening. Jury is discharged. The jury has left the courtroom. Anything further from the state?
I just want to make sure the record is clear that the two murders which are run consecutive to
Yes.
each other. I don't know if it's clear that they're to run consecutive to kidnapping and one wrong. State's request is that the murders run consecutive to each other. Around that.
Yeah, the other sentences I think are already imposed, but in any event, I agree. Anything further from the defense? And this matter stands concluded.